If you grab someone in a sexual way, that is considered a sexual battery. 243.4 of the California Penal Code. Grabbing someone at a bar, grabbing a woman's breasts or a guy's crotch area or things traditionally associated with sexual parts of your body would be considered a sexual battery, an unconsented touching for some form of sexual gratification or abuse. That is a sexual battery, and that is very serious. Many times, the sexual contact in a bar, unconsented touchings, I would imagine many don't go prosecuted because first, if the bar is crowded, you don't even know who touched you. You look around, they're gone. There may not be a camera necessarily to visually see, and people are drunk at a bar. So many times they wouldn't go prosecuted because you don't know who the perpetrator was. You turned around, there are a million people behind you. You don't know who actually touched you unless someone actually told you that it was them. So sometimes they're not prosecuted for that reason. But in today's day and age, oftentimes they can be if the victim sees who the perpetrator was, the bar was quiet, or weren't very many people there, or the person just reached right over and touched them. Or there might be cameras. In today's world, a lot of eyes in the sky. So if there's a camera, a video camera up there, they can always get the video camera and see who was personally present there to determine who did the touching. Now, sexual battery could be charged as a misdemeanor or a felony, depending upon the circumstances of the case and depending upon the district attorney assigned to prosecute your case. Sexual battery requires lifetime registration, the single worst punishment anyone can ever suffer, even worse than jail. You go to jail, you get out, and it's over. Registration is for life. So by hiring an experienced criminal defense lawyer, we can meet with the prosecutor and try to influence their decision-making process and try to convince them not to charge you with a sexual battery, maybe charge you with a simple battery. Maybe the touching wasn't intentional. Maybe the person slipped, maybe the person fell, maybe the person reached over and it was an accidental. An accident is not a crime. This crime requires a specific intent. If you don't have that specific intent, the DA wouldn't charge you with sexual battery. So it's up to your lawyer to convince the DA there was no intent, if that's, of course, part of your defense, to show that touching was not with the sexual intent involved.